your discretion when we begin.
Okay.
Oh, all right, let's turn this off.
Get everything set up here. Yeah, I think Marie's going to be late. You ready at your end, Alex? You ready?
Yep.
You ready? And you guys are ready? Yeah. Good evening and welcome to the Monday, June 23rd, 2014 special select board meeting for the town of Long Meadow. We'll start with the Pledge of Allegiance. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We're going to start with a couple of announcements. We announced this last week. I'll announce it once again. The July and August regular select board meetings will be held at the police station meeting room at 34 William Street due to summer school vacation, or school summer vacation, that's better. Our town manager is on vacation until Wednesday of this week, and I have some sports announcements other than the major soccer play this weekend. There was a tremendous amount of our young athletes in our town that participated in the Sheldon M. Roosevelt Memorial Junior Tennis Tournament in Forest Park. This tournament's been in existence for well over 30 years. I did not get the results for the 18 and years and younger, but I did get the 14s and down. Daniel Draymore, boys 14 and singles, 14 and under singles champion. Patrick Burns, boys 14 and under singles runner-up. James Foster, boys 12 and under singles runner-up. Ben Rush and Matt Adler, boys 14 and under doubles champions. Franco O. and William Horniak, boys 14 and under doubles runner-up. Patrick Burns and Jenny Brayton, mixed doubles 14 and under runner-ups. James Foster and Ashley Edwards, mixed doubles 14 and under champions. We had a tremendous outpour of the young athletes. This is not all the kids that participated, but these are the ones that actually carried home trophies. As I say, I didn't get the 18-year-olds and under, so if somebody out there has a list of them, they'd please send it to me. I'll announce it at our next meeting. We're going to start our meeting with resident comments. Do we have any resident comments? Yes, ma'am.
May I introduce?
You can go there to the mic, and please state your name and your address.
Good evening. My name is Athene Zaleski. I reside at 10 Green Willow Drive in Long Meadow and have done so since 1975. Good evening to the chairman and the select board. I appear before you this evening as spokesperson for neighboring residents who share profound concern for the group home at 222 Red Fern Drive that is proposed. Unfortunately, many of us obtained knowledge of this venture by pure accident over the last several weeks, absent any formal notice from town officials. Our purpose this evening, therefore, is to appeal to the Select Board and town officials to carefully weigh the significant consequences this venture will have upon our immediate neighborhood and the community at large. When we purchased our respective homes with the usual eager anticipation, we understood we bought into a community of residentially zoned, single-family dwellings with the added aesthetic of attached garages where vehicles could be stored overnight, kept safe, and out of sight. Over the years, we've collectively maintained our residences as a source of both individual and community pride. This latest proposal of a group home now interjects a commercial venture into an otherwise residential neighborhood of established single-family dwellings. If approved, the character of our beloved neighborhood will forever be changed by a property whose garage has been converted into additional living space of dissimilar exterior aesthetics and numerous vehicles being parked outdoors overnight. Meanwhile, heretofore, proud homeowners are handed the residual of dealing with an aftermath of depressed property assessments and the inability to sell their homes for fair market value when job or life changes arise. For the record, our assembly this evening is not to discriminate against group homes or the services they provide to those in need, but rather To bring attention, there exists a nebulous or gray area in the law, thus leaving open to conjecture whether the services planned at 222 Redfern Drive accurately fall under the auspices and guise of the Dover Amendment, which exempts and thereby grants immunity to those not-for-profit ventures whose charters stipulate such proviso and fall under the context of agriculture, religious, or educational enterprise. Unfortunately, the 30-day statute of limitations has expired for appeal of the building permit, which was granted on May 7, 2014, for the construction of the group home at 222 Redfern Drive, as no abutting residents received formal notice to this end. However, to wit, before a certificate of occupancy is issued and the town of Long Meadow crosses a threshold of no return, we collectively suggest a thorough and comprehensive investigation of not only the law governing such entities, but of the entity itself, and simply not rubber stamp this venture as a done deal when, at the conclusion of the evening, you retreat to your quiet respective neighborhoods. The Dover Amendment legislation is powerful and a generous one, as long as it's not in your neighborhood, and one which leaves no homeowner immune to the prospect of having a commercial venture, and make no mistake, this is a business, sprout up immediately next door to their home in the Commonwealth. Therefore, at this time, we petition the Select Board and town officials, through continuation of the matter, to perform due diligence before granting and thus setting any such precedents with far-reaching community ramifications. Thank you.
Can you spell your last name, please?
Z is in zebra, A-L-E-S-K-I.
Thank you.
You're welcome.
Are there any more visitor comments?
Barbara Mejero.
Pardon?
We have the same opinion.
Okay. Okay, well, I believe there's going to be further discussion tonight, because normally we do not have an open dialogue during visitor comments.
Correct.
I believe Mr. Grant is going to present a paper dealing with the same issue tonight. I can assure you that no one here takes it lightly, and that currently we're operating under the advice of two attorneys, which we mentioned at the last meeting. And I think it'll be, we move forward now and see were those opinions correct, or are there some other opinions that can come up and disprove those opinions. I think that's where we're at this point.
Very good.
I do appreciate you coming before the board again, and I appreciate you folks coming back in. You sure no one else has any comments for the board?
Paul Jelinas.
Yes, sir. Yes, sir. Can you come up and take the mic?
Yes, Paul Jelinas, 128 Eton Road. I'm not sure, but the same thing I think is happening on about 266. I'm not sure, there's no number on the house, 266 Converse. Same trailers, the same dumpster, the same temporary compartments to put stuff in while they're is the same place. They have the same stuff as at Redfern as they do at Eton Road at Converse. So it's 266, I believe.
266, okay.
Right. So I think the same thing is going on there. And I'm about 6 houses, maybe 7 houses away.
Okay.
And the people I went next door to 264, and they had no idea what was going on. So nobody got notified at that address as well.
Okay. Thank you, sir.
Can you just spell your last name?
Gelinas, G-E-L-I-N-A-S.
Thank you.
Right.
Any more visitor comments? Okay. Select board comments?
Richard, this isn't on the group home, which I'm sure we're going to discuss in a minute, but to piggyback on your announcements about sports, this past weekend we also had a number of athletes going to the Hershey State Meet. I understand that a boy named Nate Morin got first place in his age group in the standing long jump, and there were some other great performances. And some athletes who had been doing the spring track program also went to the US ATF track meet in Fitchburg.
Thank you, Alex. Yes, Paul.
As we get into the new fiscal year, I'd like to offer some suggestions to the Select Board. I'd like to see us at least have an agenda item where we talk about subcommittees, and we had them and we didn't have them. And I think there's a value to some of those things. We talked about some policies. Obviously, what's going on in Redford and Drive is maybe an issue that if we develop some proper policies or review our policies, maybe things like that won't catch us by surprise. I think on the finance side of it, on the budget side of it, I think it's important, and I would speak for myself and not for the board, that I thought this budget year was not the greatest in terms of information presented to the board and how it was presented. In years past, the Finance Subcommittee met with department heads and vetted out things to bring back to the entire board. I also like to suggest that when we have something that's presented to us that needs a vote, is that we adopt a policy that says we need to wait at least one meeting. Last meeting, we were voted on turning over the Fanny Stebbins Wildlife Refuge. We signed a lease in which we really didn't have all the information in front of us. There were even some things that the town manager said that, it was time sensitive, yet we got at one meeting where we had a vote on it before the end of the fiscal year. I think it's imperative that we take information. Our role really should be to protect things, whether it's Redfern Drive or, the Fanny Stebbins Wildlife Refuge, and having a vote, which I understand the words "no risk" were uttered, and those words should never be uttered with the word government beside them. So I think we need to have some sort of policy that says when something's presented to us that we should have to wait one meeting to vote on it. Unless it's something of an emergency nature. Otherwise, I think we keep stepping into some potholes that we're going to find ourselves at a hard time getting out of. Thank you.
Okay, now on the agenda tonight, we do have the subcommittees that you're referring
okay.
to. That's
There we go.
being brought up tonight. And your point on the introduction.
That was quick, thank
Yeah,
you.
it was quick. The point about your introduction of something like that and waiting for the next week, I think is appropriate unless it's an emergency situation, because we are finding secondary issues that are coming up. So, any more select board comments? Okay, well, old business, group home or adaptive use of single-family dwelling, public notification policy and procedures. The original intent is how do I phrase this? My intent was to come in tonight to talk about our policies and procedures and to likely establish some of our committees again, to go back and look at a lot of our bylaws. This issue as it stands right now has already opened our eyes to some possible areas where we need improvement, or at least review and modification and updating some of our policies and bylaws. I received a large amount of information today from Selectman Grant, which I would imagine he would like to present tonight and put into the record. The correspondence will be automatically placed in the record, but did you want to read your statement, Mr. Grant?
Can I ask one before you go on? Are you with LCTV?
I'm not. No, I'm with ABC40.
Okay, I'm just, because anybody can tape a meeting, they just have to kind of announce. I didn't know because.
Yeah, she announced earlier.
I didn't hear that. Okay, I'm sorry.
Sorry.
Go ahead.
I don't think anybody would want to hear me recite a 9-page, single-spaced memo that goes into a fair amount of detail about various cases and holdings and rationales and that sort of thing. I do think I would like to talk generally about the points that I was making.
You have the floor.
Well, we're actually.
Oh, excuse me. Go ahead.
Alex, if I could, I actually took the time to read the 9-page single space. I thought it was great. And I think that people ought to hear that as I read it, the summary is two things. One is that is this group that's moving in there does the group that's moving in there meet the definition of a family, either by state law or by our building codes or by zoning laws or by state law that trumps our building laws. But more importantly was your comments about, does the application meet the definition of an educational facility? And I think both of those were well-made points. I'll say personally, I think the second, which is, does the use meet the definition of an educational facility, struck an extremely meaningful chord with me, because I think that the argument you laid out and some of the references you cited do mean that we need to, as Ms. Zelinski noted, that we need to do our due diligence to make sure that the burden is on ServiceNet to demonstrate that it, in fact, meets the definition of educational usage. I don't know if I captured correctly some of the things you were saying, but.
That was pretty good reading comprehension. I wasn't sure that everybody was going to get it, but yeah, I've spoken to town council, and I think the issues are fairly clear. One is, does this group home comport with our bylaws? Is it a proper residential use? In other words, are the residents of this group home going to be deemed a single family? And then the second question is, if they don't fall within our bylaws, which I believe they don't, then is it consistent with the Dover Amendment? And the memo that I circulated to the Select Board, which will be public so people can read it, goes into some detail about the cases that have been decided by different Massachusetts courts about group homes. And in particular, there was a 2012 case, which I think is really the controlling case on this matter, called Regis College. And Regis College emphasizes something that the Supreme Judicial Court and the Appeals Court have said before, which is that the educational purpose has to be dominant or primary. So in other words, it can't just have some component of education, it's got to be the predominant one. And in fact, the educational goal has to be educationally significant. From what I've been able to determine based on the conversations that the town council had with people at ServiceNet and with Haven Homes, and some independent research that I've done, I looked at their website, ServiceNet's website about this program. I also looked at the job listing that they've posted for the program director who apparently is going to be working at this group home in Longmeadow. There's precious little education being contemplated. I think some very beneficial services are going to be rendered, but it's really a matter of a residential use, a medical use, and recreational use. In fact, the website itself describes an important part of the program as literally recreation. And this 2012 case that I just made reference to specifically distinguishes between educational uses and recreational uses. So the concern that I have is that this process has gone a certain distance without the Select Board being involved. I believe that there was some misunderstanding factually about exactly what this group home was going to be. I think some misunderstanding about exactly what legal principles control. And I think what this ongoing dialogue and having the residents come in and bring it to our attention has allowed us to do is to pay more attention to it as a town. And what I'd like to do is to have the Select Board work cooperatively with the town manager and the building inspector to come up with the right answer on this. Because this is a really important issue for the residents in that area, for this group home, but it's also, very important for other town residents where group homes might go as well. So, like I said, I believe that the analysis that I put forth is the correct one. I'd like to see the Select Board act on it. At a minimum, what I'd like to see happen is that for us to maintain the status quo, in other words, to have a directive from the Select Board not to issue the certificate of occupancy, at least for the time being. The last thing I want to see happen is somehow the certificate of occupancy is issued and then it's too late, because the fact is it's not too late. I think we've caught this in time, and it's really important that we get the answer right. So that's what I guess what I'm going to do then is to make a motion that the Select Board issue a directive that the certificate of occupancy not be issued pending contrary action by the Select Board.
Second. Second.
Discussion? Go ahead, Marie.
I sort of came in at the end. I did read through what you did, and my concern is that if we've had two councils saying that this is legal, I'm concerned that we're opening ourselves up for liability to block a program that's already here in Longmeadow, from my understanding, and that we really need to, before we start taking adverse actions, I'd like to hear from our council in regards to that. Because we can't discriminate from one program to another. And so that's why I wouldn't be supporting any decisions in regards to withholding a certificate of occupancy till I had heard from our attorneys in regards to that.
May I respond?
Sure.
The concern I have is that, and I agree, I want to get our town council responding to my memo and to have, for us to be on the same page. But if in the interim, the certificate of occupancy is issued, then it's going to be too late. So what my motion really is designed to hold us at the status quo so that we can have that discussion with our town council. And as well, if ServiceNet wants to fill in some of the gaps, I mean, really, the case law says that the burden is on the applicant to show that it's entitled to this protection under the Dover Amendment. It's really presented nothing to us aside from having a conversation with our town council. So, I think that's the purpose of the motion, so we can have that kind of deliberation that I think you're wanting to have. I'm afraid that if we don't have this directive, what's going to happen is the same thing that happened with the building permit. It was just issued without a full appreciation of the law or the facts.
Alex, I tend to agree with you. Going back around the back of my head is the question of do we have the authority to direct the town manager to withhold a certificate of occupancy based on his reading of what he believes the law is and what he believes his obligations are. But we certainly have the right to take that vote and then discuss it with them. I think we need to move this forward fairly quickly, though, with the discussion. I guess my question is, your motion says a directive not to issue the COA pending resolution of the issue.
Well, no, pending contrary action of the Select Board.
Okay, pending, so that we would then have to vote to
Correct.
to issue it. So I guess my question, and I tend to support that motion, but I need to know what's the steps we're going to do to either stand by our vote or do something contrary, rather than just sit back for 6 months and take no action. And
Well, I suspect that ServiceNet and Haven Homes are going to be knocking on our door tomorrow. One of the things that Dave Martell did is circulated some forms that he got from Springfield that they use so that you can have that development of the record so you can understand what the intended use is. We haven't even gotten this form approved, So what I'm imagining in the interim, and I think this is going to happen fairly quickly, is Attorney Martell is going to look at the law a little bit more. I think we can develop this form, and I don't think that'll take too much time. And if ServiceNet and Haven Homes want to present additional information for us to go off of, then we can also consider that. And then I think at that point, then we'll be in a really good position to, make the best decision. But what I really want to do is to make sure that we don't disturb the status quo for the moment. And so that's why I said pending contrary action by the Select Board. And I guess I'd like to make one other point. This is not a question about discrimination at all. There's nowhere in the zoning bylaws that I'm aware of, and certainly nothing that I'm attempting to do tonight, that would treat anybody differently. I mean, the issue has come up. You can't treat disabled people worse than non-disabled people. That is not what the zoning bylaws say. We just want to treat all residential uses the same. and we want everybody to apply, we want everybody to play by the same rules. So I just want to make sure that's on the record.
Go ahead, Marie.
And I think that's fine. My concern is the method that you're doing this, because by all of a sudden putting in this new step that's required, you are treating this home differently from other group homes that have been treated in the past. So since these procedures were not in place, and now we're trying to place it in the middle of the procedure, it can be viewed as discriminatory, and that's what worries me a lot. And I think that the other thing that concerns me is we're also changing who the adjudicator is in this case. Now, up till now, we have had the adjudicator has been the town council is supposed to look at this with the building inspector, and now placing this board in the middle of what the adjudication is going to be, I'm not sure if that's a wise step at all. I think that this board can definitely say, and that's what we said last time, we would like us to start implementing a program that does a more vigorous evaluation, that the Dover Amendment has been passed, and they are able to avoid the zoning. But for us to put ourselves right in the middle saying, we're going to decide how the form is going to be, we're going to decide if the form is filled correctly enough, we're going to decide the evidence is adequate enough, I'm not sure if that's the place of the board, number one. And number two is I can see that is being discriminatory because these procedures were not in place when they sent their first initial application in. And I don't think you can change the game right in the middle. A lot of the discussion we had here on the board the last time was how important it is for us to really have a more vigorous application process. But I strongly feel that we cannot withhold a occupancy. What we could do a directive is that we ask that all of this is be done in a very timely manner in the next week or two. As you said, it doesn't require that much, but I don't think we have right now the ability, and I think it also sets up for liability if this board starts to slow down the process and withhold occupancy. Where we're standing in construction, we could find out. This board could meet more frequently to make sure we're satisfied with the procedures and that we're working cooperatively with this organization to make sure the paperwork does get in. And then the end game is to make sure we have a process in place for the future. If the end game is to stop this group home from coming in, that worries me. And there's two things. One is actual procedure in effect, and the other is what appears are. And is it the appearance that this board is trying to stop this specific program from coming in? And that worries me.
Yeah, I guess my question is, and Marie, this kind of is something that speaks to your comments a little bit as well, but at this point, we have nothing formally as an application at all from this organization. What we have is a trust us it's being used for educational purposes. And, and as I said earlier, I don't know if you were here yet, but in Alex's comments today in his write-up, that struck a chord with me because, it's easy for anybody to claim it's educational when, in fact, if you look at some of the case law, people claimed all kinds of things were educational that were proven not to be educational. And so the question is, do we not have an obligation on behalf of the residents to ask the people who are going to be using this to in fact demonstrate that they're going to be using it for the purposes by which the law would allow them to use it, as opposed to trust us it's educational, and once they move in, then it's, well, if you don't like it, now try to throw us out, which is, I think the point is, it's extraordinarily difficult to do that. But there is absolutely nothing in writing that I've seen anywhere that demonstrates this is for educational purposes, with the exception of the ad that this company, ServiceNet, placed for the person working in the house, and not a thing there says educational. It says medical, it says recreational, nowhere does it say, so from my point of view, I think it's perfectly fine for the select board to say, and I'm a little bit concerned about the wording of this, to say, we should not be issuing a certificate of analysis until it's been demonstrated to us that this is going to be used for educational purposes, and therefore is compliant or meets the requirements of the Dover Amendment. And I don't believe, that necessarily puts us at risk. And so to that end, I think I'd like to see an amendment to Mr. Grant's motion that specifically says that one of the things that the select board needs to have in order to reconsider or issue a contrary statement is demonstration that, in fact, it meets the requirements as an educational utilization per the Dover Amendment, and that is confirmed by our town council, not by me, who's somebody sitting on the select board, but that it meets the requirements of an educational institution. They haven't demonstrated that at all, and I'm not willing to take anybody's word for it.
Is there a second on that motion for the amendment?
Can I just have a clarification? It's the decision on whether it's the educational is town council.
Well, no, it ends up being our decision, obviously, if we have to run contrary to it, but clearly our town council is going to have a strong opinion. If Dave Martell comes forward and says, look, this goes to court, you're going to lose, it's clearly an educational utilization, whether they're teaching classes there or not, because, and then he tells us all the case law that says it, or in fact, he can't say that. He said, well, it's kind of maybe it is, and nobody's really challenged these, and if they say it's educational, you got to, whatever it is, Marie, I think that we've got to use our judgment to figure it out. But my point is that we've never asked the petitioner for potential use of this house. They're just saying we're okay, it's going to be educational, and trust us, when in fact we have absolutely no demonstrate. Plus, an affidavit from them that says it's going to be used for educational allows us to then go in and say, hey, you're not using it for educational anymore, you've lost your certificate of occupancy, if in fact they try to change the usage at some point down the road, if in fact it does meet educational now. But right now, without asking for that demonstrated proof or written, they have submitted nothing other than a trust us. And I don't necessarily think that we need to do that. And I don't think that opens us to liability if in fact we demonstrate what it is and why we're holding this up. We're not holding it up capriciously. We're not holding it up arbitrarily. We're holding it up until they demonstrate that they in fact meet the requirements of the law.
So my question was, what is the amendment to? I didn't quite understand.
There is no formal amendment at this
there's
time.
not.
I was just looking for some clarification so that we can tell people what it is that we're looking, what kind of information we need in order to reconsider this.
Yeah, I think the very simple black and white point to the motion and the vote should be, we have an opportunity to potentially protect residents. We could fail, and it might come back and say, our attorneys might come back and say, first of all, let me go backwards. I asked at the last meeting, do we have any documentation from the company going in? None was provided from the last meeting to today. So I'm assuming the answer is no, that we don't have it, because otherwise I'm sure we would have it. So that, based on what, Alex has written up, but also what Mark just said, is we have no proof that we can view ourselves that says, it does have to go in because they are providing educational benefit. So the simple matter is, the motion and the vote should be to protect town residents. If it comes back and ultimately it's proven that it is an educational facility, or they do qualify under the educational facility or some other manner, then we did our job, which is to try to protect town residents. We can get sued for anything, and I mean, you guys are the attorneys, you know that. So, the issue is, quite frankly, is what can you do? And I really, in one way, I'm not happy this happened to you guys, but I mean, I'm happy that it did happen in one way, is that if this is going on in the other parts of town, and we're not asking for proof from these facilities, then shame on us and our government. And the visitor who spoke today or earlier, and I said this at the last meeting, if it was on your street, in your yard, you'd be fighting just as hard. And I don't see what the downside is if we're doing it the proper way, which is really should be under the auspices of protecting our residents and protecting our town. It's not under a loss of tax revenue, because this place will pay taxes, but I asked a very simple question at the last meeting. Did they just go in and say, we're exempt? And we said, okay, no problem, through the process that they filed in our building department. So I think the simple matter is, the motion allows the board to get that proof that says it is what it is intended to. And if it's not, then it's not, and it doesn't get issued. And if it is, then we're wrong, and they'll get their occupancy permit.
Go ahead, Marie.
See, my concern is this. I was very vocal at the last meeting saying, we need to have this material, we need to revamp the way we're doing things. My concern was your memo, Alex, actually, and that is that we had our town attorney said he feels on the face of this is going to pass the Dover Amendment. and we're saying we want the actual material, we want the evaluation. You're saying, I can go in and litigate this doesn't fit the Dover Amendment. And so I can see a legal argument where you're saying, well, I believe, what is the meaning of educational? Well, educational, I know the law says all sorts of things. A disabled individual staying in a home in which there is a residential counselor there, making sure they can live on their own, that can be considered educational. Well, a lawyer can also step in and say, well, I don't think that is enough education to be. So this is something that I would agree if we say town council is the final authority on this. If this becomes a legal back and forth of litigation between attorneys, we're never going to have a solution. We're going to end up, in my opinion, in true litigation because an occupancy will be withholding the occupancy certificate back due to disagreements among this board. But if we say the final adjudicator is our attorney and we're going to respect that opinion, and we had two attorneys sitting down, then I would see no problem in requesting this information and slowly start processing the homes the way they should be with documents backing up the application. But to put it in the hands of the decisions of this board, the way it's moving has me very concerned.
Please, one comment. I'm sorry, I wish I could allow you, sir, but we can't. And I apologize, I really do, because I know that you would like to step up and get in this. But the discussion has to take place up here now, sir. Yes, Al.
So, I mean, you know, when we think about the risk of litigation, I mean, we could have town residents suing us for issuing. I mean, that's another form of litigation. I guess the problem that I've had is the only thing we have in writing from town council is based on a rationale that we're not using right now. That rationale didn't mention the Dover Amendment at all. And what we've gotten was a write-up from Stephen and Richard from a phone call attempting to summarize what was said, and that was part of my concern about we're not really understanding this completely, because we have one rationale when the building permit was offered, and then we move off of that, and now there's a new rationale to permit it. And like I said, my analysis based on the available facts is that it's not consistent with our zoning bylaws, and it's not consistent with the Dover Amendment. I mean, I'm happy to listen to more facts if there are more facts that would justify it. But the concern that I have of delegating this back to the building inspector or the town manager is that we've kind of had to fight this, to give it attention. It was sort of, we weren't even aware that this issue existed until June 3rd. I mean, the way we found out was people walked in. I mean, literally, I had no idea that this was an issue. And then the quick reaction was, oh, don't worry about it, it's all legal. And, and it's really a fairly involved legal and factual question that I've attempted to plumb the depths of. But, and I'm sure town council, when given an opportunity, will do the same thing. And so to me, what this motion and directive does, it just allows us to maintain the status quo so that we can get this decision right.
Maria, I hear your comments. Our town council is advisory to the select board. And if we don't believe that, I will reference the council that we had on MGM who was advising us to do some things that we kind of went a different direction on several times. So, we have treated our councils as advisors, not necessarily as directing what we do. But I will also tell you that, I have a whole lot of respect for Dave Martell, and I think that, if he looks at this thing as closely as we're starting to look at this thing, and he comes before us and says, here's the lay of the land, folks, I think that it's going to be difficult for three people to say, no, Dave, you're absolutely wrong. I really do. And if we do, then it's on us. But I really believe that, I listened to Attorney Martell fairly closely. I think others do as well. And asking him, rather than to say, hey, call up the guys from ServiceNet and see what they have to say, and then make a ruling on it, is whole different from get it in writing and do a little case law, and then tell us what we ought to be doing, and if this is something that we should be challenging based on these specific grounds, I have no problem with. So I'm going to continue to support this motion. I think it's worth doing, and I do support still our town attorney.
Any more comments? Paul? No.
Actually, Richard, I do have a question.
Yes, ma'am.
How soon are you going to have this on the agenda? Are you going to have it next Monday?
Yeah, I think we'll put this on very quickly.
We don't meet
We
next
don't meet
Monday.
next Monday, but we may have to schedule a special
We
meeting.
might need to.
Yeah.
My concern is, so there would be a special meeting, and so it could happen in a timely basis. I'm not sure when they're expecting this certificate of occupancy. I'm not sure if it's expected in the next week or two, or the next month.
And I wish I had that information too, and I do not have that information. But I you know, if you've listened to everything that's been said, and Alex, I thought you did an excellent job on what you wrote. It's very thorough. You folks did get to hear about 3.5 pages of it. He didn't give you all 9, but it will be a public document. And I've heard the opinions from everybody on the board, and the folks have to understand, this is a very complex problem because we're in an area that we normally don't get into. We are dealing with 2 legal opinions that we have, and then we've had another legal opinion from one of our lawyers here that's done a considerable amount of research on this and demonstrated evidence that could say that the initial opinion needs further research. Not exactly, and I'm not trying to put words in your mouth, Alex, but that was my inference from when I read your document. And I'm not sure we can legally, as a board, hold up this certificate of occupancy. We'd have to get into our bylaws and our charter to prove that, because there's a lot of duties that have been given to the town manager by charter. And this is an area that I believe falls under his stewardship with his board of inspectors and all. But I understand the vote that wants to be taken, and I have to agree with that if we can hold this process at bay internally, if not just for a couple of weeks or a week and a half, until we give our attorneys time to digest the information that you've had, which you've brought a lot of different case law, and they will have to interpret that, and come back to this issue. We'll hold a special meeting. I can schedule it tomorrow. We'll get it scheduled as quick as possible. We'll talk with Dave Martell tomorrow and see how long it can take before he can bring an opinion for us. But and I'll take that as the lead. So I support the precedence that's being set up here, but I also understand that, you know, there is a point where we have to stop going for different legal opinions. There is a point where we have to say, we've done due diligence, and we have to stand still. And I applaud you folks for coming in. I apologize that you can't participate after you originally spoke. Each select board member has a email account, and their email addresses are online. Please send your comments to them. They will respond, or you can send them to the entire board, and they will incorporate them in the minutes. So if there's no other, I'll call for a vote. All in favor? Excuse me, could you reread the amendment, or the motion? The motion?
Motion, I don't know if I grabbed all of it, but I have to find it.
Can you just say your motion again?
Could you
Sure,
please?
sure. The motion is for the select board to issue a directive not to issue a certificate of occupancy for 222 Redfern Drive pending contrary action of the select board.
Thank you.
Okay, motion's been read. All in favor? All opposed? Thank you. Yes, Mark.
I'd like to ask that this vote be, communicated to Mr. Healy in the absence of our town manager here, and certainly to the town manager and through our acting town manager. But secondarily, because I believe we have a policy about use of legal counsel. I think we ought to, as a board, I think we've all agreed that we're going to have our legal counsel directed to take another look at this more specifically, given the input he can determine rather than whether a phone call or whatever it was that was taken. So I think we ought to direct our town council to delve into this a little bit more. And normally that's done informally, but I think we ought to do it formally.
Okay, I'll be on that tomorrow. The town manager's still out, so I'll place a call to Dave Martell tomorrow. He has the information that Alex has sent him, and we'll see. There'll be twofold. I'll see what he says the timetable is and when he would like to schedule a meeting. And at that point, I'll schedule a special meeting.
And you'll also talk to Mr. Pasterzik to make sure
Yeah, I
that
will.
the note gets
Yeah.
back in. Thank you.
And our town manager will be back on Wednesday, so I'll brief him totally on this issue at that time. Pardon? No, we don't take timeouts. I wish we could. Okay. Next issue up is the new business, the Select Board Budget and Policy Subcommittees. This issue has been brought up several times here recently about the value of these committees. These committees were in the Select Board Policies memorandum. They were established, I got a handout here for each of you. Paul? Yes. Okay. Do you need a copy of this? Okay. Oh, I got copies of everything if you'd like it. They were adopted by the Select Board November 1st, 2010, and the other one was October 2010. The one was the Finance Subcommittee, and the other one was the Operations Subcommittee. And these were subcommittees assigned to the Select Board to deal basically with one of the issues we have tonight, this zoning issue, which is a major issue. We had already talked initially when this first came up about needing to get committees going again that could take this issue and deal with the complexity of it. And I think we do need to reestablish the committees, and I'd like to place it out to the board for motion that we adopt these again and staff them for this year.
I would move that we reconstitute a finance subcommittee for the charge of November 1st, 2010, and an operations subcommittee as with the charge of October 18th, 2010.
In a second.
I'll second for purpose of discussion.
Okay. So we'll move it to discussion.
I mean, I guess I'm kind of just looking, you know, I'm the newest person on the board, and I guess I'd be looking for some discussion about sort of how in a concrete way, say, the Finance Subcommittee would improve our budget process, or sort of looking back on the last year, what could we have done better? I mean, to me, that's always a useful thing that guides my vote, is how does it play out in a concrete way? It feels a little abstract to me exactly what this either of these subcommittees would do.
Go ahead.
That's right, we did at the same time.
Go ahead, Marie.
Well-
Go ahead, Marie.
What concerns me is not the abstract, but as you said, you're new, is how this has worked in the past. And the Finance Subcommittee, I was not happy with, because then two people were keeping all the information and dealing with the budget. And that's like things that these 5 members should really be working on, is the finance. How you're going to divide it, how the communication is going to move. I'm really worried about the logistics of it. And when it comes to the operations, like you said, this is a very important zoning issue, and we need to be creating procedures and put them in place. If we say we're going to give them a mission that's very narrow so they can report back so we can get work moving, I can understand that, but to say they're going to deal with the whole finance or the whole operations and it's only 2 members, has to be 2, it then becomes unwieldy a power in itself, and then by the time they bring it back to this whole board just could step back against all the work that those 2 people did. So I think I'm worried about how it will work successfully.
Mark?
Yeah, I'd long opposed subcommittees, and I did that because it seemed to me to be a group of, as Marie said, just what it is, a subcommittee, but seemed to do everything. And we always said that there's only 5 of us. You ought to be able to get 5 people to agree, and if we need to, we'll put aside the time we'll put aside the time in a supplemental meeting and discuss it there. But what happened last year is that and that's why I'm not sure what a finance subcommittee is going to be doing. We clearly had a disagreement with our town manager over the role of the select board in preparing and developing the budget. You know, it's his read of his obligations that it's his budget, and he's going to prepare it and let us know what it is when it's prepared. And so I very well question whether the finance subcommittee is going to get to do anything more as a group of two than we got to do as a group of five. But it may be possible that a finance subcommittee, in fact, then can work and find out what is going on, whether it's interacting with the school committee or interacting with other folks. As I said, I'm kind of torn between here because I think the select board as a group should be able to do whatever a subcommittee can do, but the fact is that we didn't do it last year. I think, Rich, I had said to you, that by count, this is the 44th meeting of the year, but I think I missed 4, so I think, in my count, so I think this is like the 48th meeting this year. I'm not sure how many more meetings we're really going to be able to have than we had this year, but maybe we can take the time that we spent on MGM last year, which was probably 20 of those 48 meetings, and divert it to doing some of these kinds of things as a board, as a whole. It does put some directive in the hands of the subcommittees, although the subcommittees are not authorized to make any decisions on the part of the board, but to rather stay in communications with what goes on and bring it back to the board. And to that degree, it can't hurt, but the issue is how are we going to make these work? So I'm very torn between this. I'm not sure that this is the right way to go.
Paul?
I served 3 years on the finance subcommittee and can tell you, from your perspective of what does it mean and how does it work, is that we actually worked with the town manager on all things financial. And if you read the points here, to Mark's point, the finance subcommittee never made a decision on their own. And the difference is between that and how the board acts as a whole is, and Mark, you're right, it is the town manager's budget until it gets into the hands of the select board. Then it becomes the select board budget. And if you're happy with the way the process went, then I guess you don't need a subcommittee. But the other thing that happens is that we did have meetings on that finance subcommittee with the school committee finance subcommittee. Till we start talking early on about the impacts in the school budget and what does it mean with the town budget. And we had open public meetings, minutes were posted. I know members of the finance committee attended them. Members of the school committee attended them. I know members of the select board attended as well. I think if you look at the operations subcommittee, the IT consolidation came out of that committee. The IT department that we have now at the high school that works IT for the whole town came out of that operations subcommittee. Policy changes, and I know you know that the policy changes came out of, or policy updates came out of that subcommittee. And what the job of each of those subcommittees to do is to delve into those two particular realms and bring information back to the board. And yes, we can do it on our own. I wasn't a fan of subcommittees. I actually saw how it worked, and quite frankly, we worked very well with the town manager because the town manager was bringing forth what the town manager wanted in the budget as well. So if it passed mustard, so to speak, or at the time it was, Robin Crosby thought that, let me send up a trial balloon, for example, with the finance subcommittee. And we said, yeah, let's bring that back to the board. Then the town manager actually has an ally going back to the board with the information. And if the town manager still wanted to bring something, we would bring up the pitfalls of something we discussed or whatever. But I can tell you that there was definitely, and the recommendation was brought back to the finance subcommittee with the town manager saying, this is the budget we think we should approve, and here's why. And the subcommittee was actually answering questions about the budget on behalf of the town manager and some of the points. But if you look at the successes of it in the sense of the IT department that was merged between the town and the schools, that never would have happened if it had to go between board to board. It just never would have happened. You would have had 12 people in a room with varying opinions. And the same thing of when you're reaching some sort of budget impasse with the school department, that it belies communication between the two committees. And I think if you see the results of, and I can tell you that we were an agenda item at one point. The subcommittees became an agenda item, so that there was communication, and that's how it should be handled, that those subcommittees give a report at every meeting. If you didn't have a meeting, okay, you didn't have a meeting, but if you did, what happened, here's what's going on, and here's what we're bringing back to the board. And especially at budget time, there was meetings or reports on every agenda, and I know there's been committee members that have voted against items brought forth by the policy committee and by the finance subcommittee, but that's okay, that's a difference of opinions. But I think that there's a value there that when you look at the things that came out of that with, as I said, the IT department, it never would have happened, a consolidation, had two boards had to get together, and Mr. Gold, you might know, you were there as well when that vote happened, but I think that's what the advantages are. The disadvantages are minor, in the sense that you do have to, and I say disadvantage, you have to post and have publicly held meetings. They have to be in handicap accessible places. That's not necessarily a disadvantage, but you just can't go meet in a town manager's office, for example, and close it off to the public. But there was nothing that was ever held in secret. I disagree with the assessment of Marie that, no one knew about what was going on, because that's the whole purpose of the subcommittee, is to bring forth that information.
You didn't get the buzzer first.
Yeah, I know. He goes first.
Well, just between the five of us, because there's nobody here but us. Paul, one of my problems with subcommittees is that I've spent a couple of years.
We're on camera, and there are people here.
No, you're kidding me. I wasn't aware of that. I wasn't aware of that, Alex. But
I don't know how you go on from there.
I actually knew what was going on. But one of my oppositions is that I rail against it because I don't like what goes on at the school committee. I challenge anybody to find minutes of their subcommittees. Now, I was on our subcommittees, I kept minutes. Those are the only minutes there are, and I've got copies of them, they get submitted. But and we had finance subcommittee, but it's got to be open, and that's the problem. Is subcommittees tend to get, because there's a lot of them, because there's only a couple of people there. It's who's taking the minutes. You got to write up the minutes, the same as if you do it at something like this. And like I said, the other thing, advantage is issues are probably well vetted to the understanding or to the details that the select board might want them before it comes to these meetings, which would make the meetings go a little bit more quickly because people will have more facts and details and will spend less time here working out the details, which probably should be worked out in a subcommittee. On the other hand, there's less discussion and less details that come out in these broader meetings because they've all been worked out in a meeting that generally is held at 10 o'clock on a Tuesday morning, and there aren't a whole lot of people there, and certainly LCTV isn't there. So I think those are some of the advantages and disadvantages, but clearly my biggest concern is making sure that we need to be diligent that subcommittee meetings are every bit as open and as public as our regular meetings are, and that's been hard-pressed in this town in general to have happen.
Marie?
I think the only way that they're going to work is if you have a limited mission. Now, I was on the IT consolidation where we had to do that memorandum of understanding with the schools. We had a very clear directive from the select board what had to be done, and we had a series of meetings to get it done, and then the work product was returned to the select board for the select board to vote on whether they agreed to it or not, and there were several meetings for the agreement. When you have something like that, and you have a specific goal, it tends to work. If you say something like, we're going to deal with the operations subcommittee, then you get rogue actions. I've seen it, and on whether it was operations or finance, where decisions are made on that subcommittee that whole board didn't make a decision on, and those were some important decisions. So if you're going to bring back the subcommittees, they might help push the work along, but only if you have a specific task. So if we decided it was going to be Dover Amendment group homes, we have the subcommittee operational. We really want you to drill down onto what those possibilities are. A specific report has to be back to the select board at a certain date where the select board can decide on. But if you have just operational subcommittees going to meet and they're going to report to us, it was on the agenda, but 9 times out of 10, well, do you have anything to report? No, there's nothing to report. We're working on it. We're working on it. And that's what I find concerning about subcommittees. if you're going to revive them, which I can understand the need to do it, have it specific tasks, see how that rolls out, see if it does end up being successful. Because the other problem we have with subcommittees is you do all the work, and you'll spend months on the memorandum, you bring it in front of this board, and this board's gonna blow it up because they didn't like certain aspects of it, so they're redoing the work. That can happen also. I'm not saying it happened with the memorandum, but it came close, because 5 members had very strong opinions on how IT consolidation was gonna work. And some of those were really valuable opinions that didn't come in because they weren't part of the operational subcommittee. So I would say narrow the focus, have frequent reports, have drafts be brought back to this, and so all 5 people get the input, so you actually will have success at the end of the project.
So, well, I'll just kind of, obviously, I'm not speaking from the experience of having served on one of these subcommittees, but I'd like to echo a couple of things that I think Mark was saying. One is, there is a very different way that school committee meetings go in the select board meetings. And I observed this long before I was on the select board, that school committees has a lot of subcommittees. The school committee meetings, a lot of times, are really there to ratify what was done in the subcommittees. And let's face it, nobody is watching what's going on in subcommittees. So it tends to be a very sterile meeting. I mean, I guess there's good sides and bad sides of us deliberating on air, for hours at a time, But, I think it is a knock on openness to have these subcommittees. And I guess the other thing that I was thinking about as we're having this discussion about the budget, I mean, if we're really talking about wanting a more collaborative approach on the budget, this subcommittee, it's almost like ignoring the elephant in the room. I mean, if we have this vision of the town manager, look, I'm going to go do my budget, don't bother me, and then, and then I'll present it to the select board. I mean, ultimately, we're the ones who have to set the warrant, right? So, to me, that structure naturally suggests that the two sides, not two sides, the town manager and the select board should be working together. The town manager should be working to present a budget that the select board is apt to want to pass, and that's why that, back and forth needs to happen. I mean, I'm a little concerned we could set up the subcommittee, and it might go the way of the casino subcommittee. We had the casino subcommittee last year. That seemed to fizzle out. So I'm not too sure about it. But, I mean, I guess the thing, I mean, Richard, you seem to, I mean, you haven't spoken. You're being a deferential and good host of the meeting. But, I mean,
I'm absorbing.
Yeah, so, I mean, I'm guessing that you feel strongly about this or see a need.
Before you answer, can I just, because you're being nice and deferential, so let me just, in each of the 3 years, just so you understand that I was on the finance subcommittee, 2 members of the select board each year for 3 years voted against the budget recommendation of the town manager. That was also worked on with this, so there is discussion, there was never, if we had nothing to report, we said we had nothing to report, but generally, for example, there's been some items that have gone before the finance committee as a reserve fund request. And even though anybody can go to the finance committee for reserve fund requests, we were uninformed of that. One of the things that the finance subcommittee did was heard those requests, brought them back to the board, said, hey, this is what's going on, the town manager explains them and that type of thing. The committee was, I can only speak from the committee that I was on for the 3 years, is that we were active. We met with, when we had our meetings, they were very open. As I said, members of the finance committee were there, school committee. I know there was one member who was from the audit committee was there at one of the meetings. There was another select board member who came a couple of different times. So they were open. They're very open. Minutes are taken and minutes are posted. What it does, though, is that it actually takes the issues that are at hand, and the same thing with the operations, we're looking at the policies and what's going on, and obviously we see a need that policies need to be, not just with Redfern, but way before that as well, that policies need to be updated. And that's what they focused on, and they brought that information back to the board. There was never 100% buy-in that the finance committee recommended on any issue that said, okay, you recommend it, and I can tell you that if you go back and look at the meetings, go back and look at them, they were not sterile. any stretch of the imagination. They were just as lively and active as we had this year, and then some probably. So they were very debatable meetings, very debatable points that were brought forward. But what it does do, I think, is it brings assurances to the board that the issues that we think are important are worked on, whether they're policies or finance or whatever. And I think that not knowing as you went into the budget year is worse than if you had a couple people that work with you that have a charge, whatever the charge is, saying, here you go do that. And I think that we just went through a year where subcommittees would have been valuable in terms of reviewing things before they got to a board meeting. And that's just my belief. But I can tell you, for 3 years, there were 2 members in the select board each year that voted against the budget, even though it was recommended by the town manager and the finance subcommittee.
Alex, I was just looking up some minutes of subcommittees of both the operations and the finance subcommittee. I'd be glad that they're back from 2010, but I can certainly send them to you if you want to see what they look.
I just have a question. The policy manual that you send out to us, it talked about it coming in 2010.
Right.
Now, I think I came on the board in 2011. Before 2010, did they ever use subcommittees?
I don't know.
Yeah.
I don't have the history back up on
The
that.
first time that we had him was the year
2010?
2010.
Okay, so we
Prior to
worked
that, no.
prior, under the new charter, groups of 5, we did do fine without subcommittees. 2010, they were introduced. Okay, that's what I wanted to understand.
Okay. Can I speak now? I totally agree with what Marie said. If a subcommittee has too many tasks, they end up places you don't want them to be. I'd like to see the focus narrowed to what serves the purpose of the select board too. I do support subcommittees in governmental operations because they're used. Committees are used all the way up at the federal level and at different levels. There is a very beneficial factor. Mr. Gold mentioned what were 44, 48 meetings and counting. We have proven time after time that this board does not have enough energy or time available to research a lot of this stuff. You take the tour on researching, you see quite often, I do too, but it is at a sizable loss of personal time. I don't think the people are aware of how many hours is put in when you dive into these issues and try to get to the bottom of it. I do support, and I would support Marie's aspect on that, narrowing the focus down to where it's more reasonable or with a central thrust. But I do support subcommittees. I see a benefit to them. Further discussion?
I mean, I guess as I understand the motion right now, this would sort of adopt what was adopted in 2010. I mean, the operations subcommittee seems, I mean, at least the way it's written, is focus on FY 2011. So I'm not sure. I mean, we'd probably have to do something
Well,
with
here's
that.
the odd thing. Actually, these committees are still operational. All we need to do is make assignments, because this order has never been rescinded. Now, I think 2 years ago, they dropped the committees, or a year ago?
2 years ago.
2 years ago, the committees were dropped off, but the policy was never modified, so basically, this policy still stands. This was taken out of the current procedural manual.
Right.
And I thought it was appropriate to bring it back to the board, since they had discontinued the use, to see how the board felt about it now. But this issue on Redfern and some of the other issues this year has brought to light that there's very likely a strong possibility these groups could really benefit this board and decision-making process.
Based on that, I'll withdraw my motion.
Pardon?
I said, based on what you just said, I'll withdraw my motion, since they've never been,
Yeah, they have never been abolished officially. They were, I guess you suspended them. We'd have to go back and see what the vote was. Do you remember what it was, Mr. Gold? I believe you were chair.
Just didn't fill them.
We just
Just didn't fill them. Okay.
Yeah.
I mean, I guess you know, like if we were to use this Redfern example, to me, that it's less of an issue of subcommittees. I mean, because to me, it's a question of judgment. You know, it's like, you know, or as lawyers, we say issue spotting. You know, a lot of times a lawyer doesn't know what the answer is, but they can at least know there's an issue that needs to be looked at. And I kind of feel what happened with Redfern is that, you know, I think people in town government didn't realize the importance of the issue. And I'm not sure that us putting two people together is going to affect that. I mean, I suspect we're going to be disappointed if we think it would.
Not if we get the right two people. Yes, Marie?
Well, I guess I think this is a good example. Let's use Redfern. So we got an operational subcommittee. If you do narrow the focus to say we're just going to do the zoning, and then you are chosen, and let's say myself to go on the subcommittee, we come up with a report. Alex takes and gave us the memorandum afterwards, saying he didn't like what we did. And he said we didn't go into it correctly and in more detail. So when you look at the composition on this board, I'm not sure if you'll ever get acceptance of what the subcommittees are doing. And that's why I think that instead of just saying subcommittees in general, if you want to take a specific thing, like let's say, zoning for group homes and rentals, and ask two members of the board to step forward to do that, and then bring reports, I would say it's almost like a task force rather than to just revive the general that are listed under those 2010 policies, which only lasted, it sounds like, 1 year. That was the only year we ever had subcommittees. We never had them before.
3 years.
3 years, so it was 2010.
So this,
2011, we did not have them.
yeah, this may have
They
been,
were there, they're fine, I was.
But
on
I
the
was saying
finance-
they were never
No,
staffed.
that's not true. Maybe
Yeah.
on the policy, but on the finance committee, we were there for 3 years.
You were, okay.
Yeah.
So that's why I would think if we're going to, I would move that the subcommittees have specific tasks or mission given by the chair or the select board, rather than just keeping those open.
Let me tell you where we're missing the boat, is take Redfern out of it. It has nothing to do with Redfern, because the policy subcommittee probably wouldn't be looking at Redfern because of I mean, unless you were looking at zoning, for example, as a revision, okay? But there's things that we have in our policy manual, and we violate some of our own policies. Our water and sewer policy, for example, where we want $500,000 as a minimum in our water and sewer, or our retained earnings account, we're at $200,000. So a policy review would say, is $500,000 needed, or is $200,000 needed? And if it's 500, then we're screwing up somewhere along the line. On the finance subcommittee, let me go backwards. We had fees. This year, the town manager said, we're going to split the fees up for review in the fall and then based on the fiscal year. We had a review in the fall, correct? 2 meetings ago, the town manager said, we make no recommendations, we don't need to do a review. That's our role as a select board, to do a review of fees. And we let it go. And I meant to mention that during select board comments, I'd like to bring that back. Because we review the fees because we're the only ones who can set them. And that's what a finance subcommittee would have done, was say, okay, what are the fees, what are the adjustments we need to make, and bring that recommendation. If you don't want to do this based on the 5 members of the board and that there'll never be agreement, then I think you just set the tone for the rest of the year. Because the subcommittees can't do anything. They can't commit to anything, they can't vote on anything, they can only bring recommendations back to the select board. And I think that we're getting a little bit off of what the idea is behind them. It's pretty clearly written of looking at it, and you change the date from 2011 to 2014-15. And the bottom line is very simple, is the subcommittees can do work for the board that the board isn't getting done and presented back to them. And my suggestion is, take a vote. If you don't, well, actually, I don't need a vote. I rescinded my motion. So if the board doesn't believe it's needed, that's fine. But if you believe it's not needed because 5 members of the board aren't going to agree upon it, that might be a great idea not to have them. And like I said, you set the tone. But I can tell you, for 3 years in a row, 2 members of the select board voted against the budget every year for 3 years.
I would look for a motion, since these committees are there, I'm going to look for a motion if someone wants to place it, to restaff these committees.
Well, I'll let someone else do it, Richard, because if
Okay.
there's no support for it, there's no support for it.
That's true.
Yeah, and actually, I think up till now, it's really been up to the prerogative of the chair, wouldn't you say?
It has. I found a memo here, I was looking through these things from our former town manager, who said that it's up to the chair to to appoint them, but it has to be done in a public forum.
I
that
knew
they-
it would come back to me.
Well, then why'd you waste everybody's time?
Yeah, wasted everybody's time. Okay, I will take this under advisement and report at our next meeting. I'll put it on the agenda, okay? I will gain a little bit more input from each of you.
Oh, you really want that?
Yeah, I'm afraid I do. Okay. We've got, I've slipped another element on the agenda, under the new business, and this is a real quick one. In our policy, we have procedures that we're supposed to follow for our legal team, for gaining access to the attorney. And I redirect everyone's attention back to what our policy states. And it's fairly succinct. I know this year we got a little bit off track with the casino work, and we opened the door up, and would you like a copy too? And I'll redirect us back to the policy that is currently in our book. This was approved, adopted by the board 2005, April 19th, and it's never been rescinded, so it is still active. And it basically says all of the legal activities will go through the town manager. And of course, you know, as a chair, I could recommend the town manager directly to have it, so I could put a request in, but that they be funneled through that person for the reasons attached. And I just wanted to make sure everybody was updated on it, so that we, yes, Paul?
No,
Or,
go
excuse
finish
me.
your statement.
Yeah,
Finish your statement.
so that I'm going to call our attorneys and re-instruct them that we have a policy in effect, and that from this day going forward until it's superseded, that we will be looking more to the town manager to direct legal assistance calls per the policy. Yes.
Yeah, I appreciate that. I think that I'll tell you that the intent of this was because at one point we had individuals pretty well running up our legal fees.
Yeah.
And so the intent is that our town attorneys are our town attorneys, not individual attorneys, with the following exception. I think it's important for the select board members to understand the exception. And the exception is that if there's a concern that any elected or appointed official has about conflict of interest, they may consult with the attorney directly without going through this request for services, but their request has to be limited to addressing whether the attorney believes that their actions may constitute a conflict of interest for them. And I think that's important. I'm not sure how many times it's been used, but
Right.
I think we need to do that. That makes it a little bit difficult but it's intended for me and you and all of us and all of our appointed board members that they not call up our town attorney and start the clock moving, so.
Right, yes, Marie.
And I think the other exception is, let's say we're in the middle of a discussion of something, and I remember the cable advisory, and if you needed to ask a specific question and you wanted to speak to an attorney, you needed to get the chair's permission to do that. So I think the chair has a little bit of ability to make the contacts also. Don't we consider the chair like the point person with the attorney?
The policy doesn't address that way.
Doesn't?
Yeah.
And it was specifically some of our committees that were using up the attorney's fees, and we wanted the committees to go through our town manager.
Yeah.
And so I'm not sure that the committee chairs are exempt. I don't know what you do when you're sitting there in the middle of a negotiation, but if you're negotiating and you don't have an attorney present,
Yeah, you
then you
shouldn't be
probably should take time out and get approval anyways.
Right. Yeah, and it's not intended to stop anything. Like Alex, your thing that you made up, excellent document, and this has to go to the attorney. They have to at least read what you've produced.
Right.
So there's no intent to stop that action, but it's just to funnel the actions through a control person. And I know last year we did get a little bit off because there was a reason for us to vary off the track a little bit. But I just draw our attention back to our policies that we have, and that we can start complying with it. And I don't anticipate any problems. I don't anticipate there being a stoppage.
Well, could I
Yeah, sure.
when I came on the select board, town council, I think it was the week that he invited me, it's like, here, let's have coffee. Sure. And he says, I meet with whenever a new person is selected, you guys did this, and I just get to know them. And the way he said it to me is that it was somewhat more informal. So like on this thing about the Redfern, I never asked him for a legal opinion, but it was sort of a little bit of a back and forth. I got the opinion letter, and then I sent him my view on it. And then you guys had your conference call, and then I think he said, oh, by the way, we had the conference call, and then I think I said, geez, I'd be interested in knowing what the cases are. To me, that sort of back and forth was very productive. And I guess one of the concerns I would have, like in this particular instance, I mean, what if the town manager says, you know what, Redfern Group Home is great, and I don't want to revisit the question, you know, and.
We have the authority under all of these to overrule the town.
No, I get that, but, I mean, you know, that's a very cumbersome process,
To
you
Alex's
know.
point, are we saying that this policy is what we want the select board members to send a written request to the town manager?
Actually, Paul, it covers everyone, departments and officials. It looks like it
Because
covers
I'm
everyone.
going to go back to the point where, you know, when I asked for some information, the town manager said, here's a policy, the select board, that said, all requests for information go through the town manager. And I can tell you the intent was, we had one person from a committee who went to the town treasurer's office, and it would happen with other town employees, and asked for the deposits for the last 30 years or something like that. And the select board adopted that policy so that those types of requests would go through the town manager, for the something similar to this, to say, why do you need the last 30 years of deposit, for example? What's the purpose of setting up the track, you know, what are you looking for?
Right.
So, you know, sometimes someone's looking for something that is easily answered, and it prevents an employee from, you know, taking 3 hours of their time to do something.
Right.
I don't believe I've ever seen this before, where select board members were asked to put in writing to the town manager to seek an opinion from town council. And all I remember is one of the things we talked about was, if there was going to be someone seeking an opinion from town council, that the rest of the board would know about it.
Right.
So if there were two members, for example, seeking the same opinion, you wouldn't have two people calling them, for example. I understand that's a select board town manager policy. In other words, that's a select board policy created by the select board.
Right.
And as Mr. Gold said, it really was, that we had committees that were going to town council, running up legal bills, and asking them questions that may or may not have been pertinent or needed to be answered by council. I don't think that ever applied or was meant to apply to select board members, to say, if you have a request of town council that it goes to, that you need to submit. I don't ever recall doing that. I don't think anybody on this board has ever gone to the town manager and say, can you get me a legal opinion, because I don't want to call town council myself. The board may have acted that way as a board,
Right.
saying that, but
You know, and as I read this,
Well, wait a minute, Ally.
oh, I'm sorry.
Actually, when I came on the board, that had become an issue. And I remember in 2011, the discussion being, you can't go to town council, where the bills are going up, and it was select board members specifically. So what I understood the process is that if I felt I needed to ask an attorney a specific question, I went to the chair and I said, this is a question I would like answered. And then the chair told me, well, we've already got this answered, this is what's happening.
Right.
Or, you know, I will pass that on and get that opinion, or at this specific instance, go ahead, you know specifically what you're going to ask. So I think the chair is an important part of the whole process, because we really can't be having only the written, because this is a board of 5, and I think we need that point person like yourself who's going to coordinate what's going on in regards to getting legal opinions. So I think the written is fine, but I think we need to have the chair in on the decision-making in regards to where we're going for what.
So we need the operations subcommittee to rewrite this thing, don't we? The wording needs to be changed a little bit, because it can be interpreted any way you want. It says officials, and I have to consider ourselves officials.
Yeah.
That's how it was intended.
Yeah,
And it was intended that way. It was
Yeah.
just the fact that you went to the town manager, but you also went to the select board.
Not at all.
Yeah.
But, and I totally agree with what you said. It would not hurt a bit if it funnels through the chair, so at least the chair is aware of what's going on.
Yeah.
And there may be another opinion that's already coming in from another member and they haven't chatted about it. Okay, then, well, how about if we go back and rewrite this language here? Now, I assume this policy, this only is a vote of the board. So I put this on our next.
What did you just say?
We'll rewrite the language of this policy to go in more in line with what Paul's recollection is and what Marie said, that we'll strip out that word, or redefine what we want the meaning to be. And that the board has the power to go to the attorney and request power without going to the town manager, which we have anyway.
I would just say CC chair. That instead of rewriting the form, just say CC chair of the select board.
Do you want to leave the officials on there on the back?
Yeah, we're an official.
Well, I disagree with that reading of this policy. I mean, and part of the reason why I read officials not to include us is I look at the request for legal services. I mean, have you tried other legal resources? I mean, really? Are we going to encourage select board members to try to look at law books, state agencies, the internet, and all these legal...
Only the ones qualified.
On legal point, I mean, to me, what this seems aimed at is employees of town government that could get something simple answered through a law book or on the internet or something like that. I mean, I guess, to me, the way I've interpreted the use of town council, I mean, I would never approach Dave Martell to say, can you give us a legal opinion? I mean, you notice when the Redfern Drive thing came up, I asked for, I brought it up in the meeting. I said, we want, so it's the will of the board to ask for a legal opinion. But if this were to be interpreted to say you literally can't communicate, word one, I think that would be a very cumbersome process.
I don't think that's what we wanted to do. I think we wanted to make this so that it was understood that the select board had the option to go to the attorney without going to the town manager.
Okay.
And the way this is written, it could be interpreted that, and Mark, you said your beliefs are it was written this way.
I know at one point we drove up I think it was our labor council fees quite high one year by everybody calling separately.
Dave, do you have tapes from 2005? Oh, yeah. Okay, well, let me shelve this issue, and I'll go back and review the tape, and I'll see what was talked about.
Actually, more important than 2005 would probably be 2011, when we drilled down and that problem actually occurred, and that's when we talked about limiting select board members picking up the phone and calling council.
Okay,
So that was in 2011.
Do you think you can drill around and find out which meeting it
Well,
was?
I
And I'll go view the
didn't, I
tape.
didn't come in till June.
Okay.
Before we go into
Yeah.
that, let me just go back and just say this to you, that that policy was created 2 months after the town manager took hold of office here in Long Meadow.
Right, in Long Meadow.
Okay, so that was in May, or April of May of 2005. The town manager started in March of 2005.
Okay.
So let's just be very clear, this had nothing to do with 2011, it had nothing to do with it had nothing to do with the Labor Council. That was a completely separate issue that we shouldn't even be talking about on television. The issue with this, as it was with information requests from department heads, is that it was meant to curtail committees that are appointed by the board. Planning board has rights to town council. They do not have to get select board or town manager approval to talk to them. They have rights to legal land use council because that is part of their role. Zoning Board of Appeals is the same thing. Other than the school committee, which has their own council, there is no other board and committee in town that needs to go to town council without the select board / town manager knowing. That policy, in my belief, has nothing to do with members of the select board. It has to do with the committees that we appoint that were going to town council, and as was the information request policy, going to town officials. It had nothing to do with 2011. 2011 was a totally separate issue that was very unique in how it was, and it was something that Had nothing to do with that policy. So before we start, if you want to go back and look at the tape for that and find out why, I wasn't even on the board at that time.
Yeah.
Okay, and I think.
before they invented dirt.
No, pretty much. So that was 2 months after after town manager was here.
Okay.
But I think we need to understand that was, in my recollection, I've never had anybody say you can't go
Okay.
to town council.
Okay, I'll view the tape, and this is the second issue I brought up, that's falling back on my lap. Yeah.
You just wasted our time again.
Yeah, I
That's
wasted
it.
your time again. Let's see if we can get on to something where I can waste your time. Now, I better preference that differently.
Yes.
The next item is the performance improvement plan for the town manager. We had quite a bit of discussion on this in the evaluation process, and I said that I would start to do a little bit of background work and to work up some stuff. And what I'm going to present tonight, and by the way, I will send you electronic copies of every bit of this tonight when I go home. Pardon? Yeah. Well, I know Mark wants his electronics. What I've given you right now is nothing more than just the bulleted items that was on the performance plan. Here, I've got one. Oh, you got one? Okay. The second one I'm going to present to you was kind of an encapsulation of performance comments, just randomly taken from all the evaluations, and we can cross some out, we can add some, we can do whatever you guys would like. I just wanted to put a general flavor out on what some of those were. What do you need, 3 of them there, Paul?
Yep.
Okay. And the fourth document that I have, you see, I do not have a life. The fourth document I have,
So don't have any trees left.
no, there's no trees. I hated to do this too, Mark.
You can see the neighbors now.
Yeah, I can see the neighbors. The fourth item is the performance action items. These are items of consideration that we may want to look at, and I apologize, for some reason, the copy machine did not pick up the draft watermark on it, but these are in draft. Considerations that we may want to look at for us to, for when I talk with the town manager about some performance-related issues, is to have some points where we may be able to gauge improvements so that we can have a quite a bit better evaluation of our town manager at our next go-around. We can take and open this discussion any place you would like, and we can also leave this discussion at this point right now, since I presented the documents to you, and that I can give you the next couple of weeks to digest this material and think about it and read over it and be able to get it more in sync. I apologize for giving you such a voluminous amount of stuff at this point. I know you haven't had the opportunity to look at it, because I was working on it as of even 6 o'clock this morning, trying to finish up some of this stuff. So what would be the flavor of the board?
I would agree that, if we're just looking at these, what I would like to see the board agree on is if we agree that instead of trying to take those 10 points and muster something up, that we take them, as we talked about when we did the evaluation, of a couple at a time, and work on 2.
Okay.
And when we feel that those 2 are satisfactory, then we go to the next 2.
Okay.
And I think that's fair to the board and to the town manager, that we take steps as opposed to coming up. And I'm just saying, we talked about it once, that instead of taking out 10 items and throwing them out on the table and saying, improving all 10, and it's got to be to 5 people's satisfaction. I think if we take 2 at a time and drill down to what we want as a board, then and again, when we see improvement, we go on to the next 2. And I
Right.
think that just makes sense for all of us as well.
Right.
Because to monitor the improvement into 10 separate items.
Right, well, as I say, I've got all the 10 items,
Yeah.
and I put in some bullets that could possibly be on consideration of what we would like to see. And this is where the discussion is going to be with the board, is what do you want to see? Everybody's got a different opinion. Now, Marie did give me some comments this afternoon via email, and I did incorporate her comments in here. By the way, I think we had 2 or 3 of them that we had already had in there, and we did not confer prior, so. Would it be the board's pleasure then to take and absorb this for the next couple of weeks, and we'll put an agenda item on for our next meeting to say discuss maybe 2 of these? Yes, Mark.
Yeah, the answer is yes. I agree, Paul. We ought to pick 2, but I'd like to pick 2 tonight, if we could. just the categories, so that we know which ones we're going to focus on and get more back to you, as opposed to going through all 10 and deciding we're only going to pick 2. Now, if we, 10 minutes from now, we can't come to a consensus on 2 of them, maybe that's not going to work. But my hope is that if you look at what the comments were, they, to my mind, they focused fairly clearly on a couple of these items as moving more to the top, and so I think that perhaps we can do that. And if somebody wants to know what 2 come to the top, I'll be glad to share my opinion.
Your top 2.
That's right.
Well, why don't you share your opinion?
Elements 1 and 3 are my opinion.
You would like to see those addressed as the
I
first
think those are the
amendment.
first 2, but that's my opinion.
Yeah.
Do you want, go ahead, Marie.
I guess my concern is that the same thing that I had a concern with the evaluation, and that was a lot of it is subjective.
Right.
I'd like to be able to set the goals that we can actually see the goal met and see that there's progress towards goals. So that's why I sort of made it a little more concrete of what we were looking at the end. So when we're talking about service and support of the select board, that's extremely subjective and how we're going to, unless someone can think of a way to really narrow that down. So I'm a little worried about starting with that one. And then some of these others, I think that we need to give him a heads up. If we're talking about budget preparation and starting earlier, then we really want to consider budget as one of the things that we're going to look at.
Right.
But Marie, if I could, one of the elements is exactly the performance appraisal document. And it defines what is meant by service and support to the Board of Selectmen. It is, responded as responsiveness to and interactions with the board, quality of agenda information, quality of research and analytical work, quality. Yeah, there are 7 items there, but it defines what those are. I think if we go back to, it's kind of like teach the test. If we define what the performance appraisal is going to be based on, it does define those elements for me.
Well, quality is where I think I have problems with.
Clearly, but
Yeah.
Well, it is
that's what
everybody's
we're gonna-
performance review, whether it's the town manager giving it to a department head giving it to an employee, is subjective. Because you can say, we want Converse Street paved. It's paved. Might not be to the satisfaction of anybody in the room, but it's paved. So it is subjective to a degree. So you're not going to get, when you're doing a performance review, and whether you're answering to 1 boss or 5, it doesn't matter, the performance review is going to be subjective. The difference is that there was a consensus, at least, that it wasn't meeting standards, or some sort of standard. And I think that's what we need to get to, is that where is it going to be to the point where the board says, you're at a 3 or above? And I think that's really what the step is, get to that point, and we really got to work with the town manager to get to that 3 or above. It's not, and if it's, and it's going to be, if you add those scores together and average them up, if it's something that we're seeing progress in, and it's something that we've already defined, and I don't know how you make things that people have to give an opinion on concrete. I mean, I don't know how we do that. I mean, you can narrow and that's why I think if we just choose 2, and you start with 2, and then when those 2 are at that 3 level or above, and that's where we come in and monitor it, then you go to the next 2. And I think, quite frankly, to, Mark talking about 1 and 3, is if you really start to work on 1 and 3, I think the rest take care of themselves. Because if 1 and 3 are working, then it has to work with all the rest of the other 8 there, in other words. So, because providing information is part of the budget process, not saying that they're 1 and 3 are not going to say when you start the budget, it's going to say what's the information being provided. So I think those are 2, I mean, my only thoughts would, number 9 was something too, but I think if you take care of 1 and 3, you get to them all. Or at least you get to a better understanding, a better working relationship.
And you do realize that once you guys have had enough time to look through this, you may want to throw out half of what I've sent you. I mean, you may really disagree, so that's why I said, my copy says draft, because it is draft. This was the first stab to just try to get something into your hands so you could start to chew on it a little bit. 1 and 3, they're very powerful elements. That's service and support of the select board, or the Board of Selectmen, and in managerial skills. There are a couple of heavyweight issues in this performance plan. They're very important issues. I think that's why Mark grabbed up on them. They're all important. But some of the other elements, I do agree with the comment you made, Paul. When these get cleared up, a lot of these other elements are going to fall in place. a sizable amount of the comments seem to center around, Marie, as you remember, was communication. And I think that's likely the one area that likely needs the most modification or improvement or understanding is how does Stephen communicate with us as a board? And I tried to focus in on a lot of this was communication, and I may not have grasped the point. That's why I'm going to ask for your help on this as we build this, because this document is our document. This is our contract for performance improvement for our town manager, and I think if communication alone improved, I think a lot of the things that we found before would disappear. And I think that's what we got to do is try to find ways that we feel comfortable with the communication and it's being adequate and that we feel that, you know, our wisdom is being accepted and we're allowing the town manager to function in the full scope of his authority. Yes, Marie?
I guess the other question is, so we decide on the action items,
Mm-hmm.
and what is the process? Because there's got to be some interaction.
Okay.
Now, are we going to send our comments to you, and you as the chair is going to sit down with them on a weekly basis or bi-weekly basis to say how things are going so that there is some communication on
There will
progress?
be. Right now, I'm meeting with Stephen every week.
Okay.
And I'm meeting right after our regular Monday night meeting that Tuesday morning to debrief the meeting and also encapsulate some of the points where I thought that there could have been improvements or some of the strong points. And I'm going to firm this up, and I'm going to start to convert this into notes that come back to the select board for communication so that you know what I'm doing. And it is an open process because, you know, it's for all of us. It's going to be very difficult, 5 to do it, so I'll do it if that's what you guys want me to continue to do, and I will keep you in the loop through some form of communication.
So the process would be, and I'm not putting words in your mouth, I'm trying to understand. Let's say I see something that I'm unhappy with Maple Street, or an example, and so I would send that information to the chair, and the chair would go over that we weren't communicated clearly on what was occurring on Maple Street and would prefer or do we still send it to the town manager, our concerns, and CCU?
Yeah, I think if I'm in the loop, then I can use that as my tickler list.
Okay.
But no, I'm not wanting to stifle communication. That's not the intent. My only intent is to take all of your viewpoints and your feelings and try to put it into a document that I can deal with the town manager and give him specific points that he can improve on to demonstrate back to select board members that there is improvement.
So your advice is then for us to CCU any concerns we have in regards to the way.
I will leave that up to you, but if you CC me and it's something that falls in line,
Right.
then I'm able to take it with him, or CC me, or however you want to communicate.
Okay.
But I certainly don't want to circumvent anybody's right to the town manager, because we have equal access to the town manager. I'm just trying to be the vehicle here. Any other comments? No?
I just comment that I'm glad that you set that up with Stephen. I think what you're describing is a really good process. I think, and I think it, you know, should work out well, especially, you know, if we're getting feedback as well.
Well, communication will increase. We've got off to kind of a rocky start. We've had, I don't think there's ever a smooth start to this position. So, is that what all the other chairs have said? Okay, so what I've given you is a draft. If you guys want to go ahead and vote 1 and 3, that's fine. We can center in on those. And what I'd like you to do is to do some honest review of what I presented on the performance action items, because that's the items that we really are going to be looking at to focus towards Stevens for improvement. And if you don't care for them, communicate with me, and we'll modify these elements. And by our next meeting, I should be able to get out, I would hope, a final draft on the 1 and 3 anyway, or a final draft on every one of them if you can comment on the entire document. Okay?
Could you repeat that? So are we voting on 1 and 3, and
No.
then you're going to
No.
make a decision on the action steps next time?
No, Mark was saying he preferred if we just took 2 items so that we could kind of center in on them.
Okay.
To get the process started. And what I have is a draft, And if you want to, if we're going to take 1 and 3, focus your immediate attention on 1 and 3 and see if you agree with the points
Okay.
that I've mentioned. And if not, feed me information and I will adapt the plan and get it back. Because, I mean, some of you might say, well, just get rid of the items. I mean,
Well,
yeah.
I'd make a motion that we that focus on elements 1 and 3, and that select board members provide you feedback on the items that you've suggested at the next meeting, we, come up with a list of action items for 1 and 3.
Second.
Discussion. You should be able to communicate directly with me because it will not constitute an open meeting law violation if you independently communicate with me on this.
Okay.
Since we've already talked about it here, I can't, we're not going to have an open debate, so, okay? And then,
But not serial.
not serial.
Emails, not mass
No-
emails, just
yeah,
directly
No mass
to you.
emails.
Right. Okay.
And then what I will do, I will modify these 1 and 3, and I will present them at next meeting, more or less a consolidated final draft, okay? Hopefully.
Okay.
And if we get a debate going, we'll just move it from there, but at least we got the process started, and hopefully we can continue with it. Boy, I still got stuck with this one too, didn't I?
You got to call the vote.
Oh, excuse me. Yeah, can you have a vote? And I was trying to let that one slip. Discussion over? All in favor? Aye. All opposed? Motion carried. I believe we have exhausted the agenda for this evening. Yes, sir.
Just, if I could, I've got a related item to this last item, and that is our performance appraisal of our town manager, I don't think has been formalized. And by that, I mean there's been no written summary document. There's currently all we've got is a compilation of 5 different documents, and I believe that we owe it to him to have a single document, not only to the process to put something together. I would suggest, and I'm not going to make a vote because I think we ought to do this by consensus, that Mr. Foster and our former chair, Marie Angelides, who it was done under, sit down together and come up with a single document that they then bring back to the board for a formal vote.
You want me to second that?
No, I'm not, it's not a motion.
Oh.
I have a question. Shouldn't this next step action plan that we're putting together be part of that, though?
My personal opinion is, I think it ought to be noted that we, as our, part of our performance, you're going to do it, but I wouldn't get into the details, that the details of this are part of his performance appraisal. Performance appraisal is a backward-looking document, and what we're looking at as a performance action items are a forward-looking document, and I'd like to not confuse the two. No sense we can't reference that there's a, and I think we did, one of the comments is that we actually took a vote that is part of his appraisal, that we would have a performance action plan going forward, and so that ought to be included, but I don't think the details need to be.
We could incorporate it too, Marie, as part of the summary, that as an aftermath of it, that there would be a performance improvement plan developed. It can be all part of it.
I'd be glad to work on it. The concern I have is this, is that the compilation with the current open meeting law is a public document. Now, if we go and we narrow that down and we make an abstract of it, we would have to bring it in front of this board for a vote, because the abstract is never exactly what the original document was. And so there's always going to be a subjective value on what we pull out into the abstract. So, if we do work on this, it's got to come back to this board for approval.
Absolutely, and I think I suggested that. I mean, the only problem is, you can't have a performance appraisal that is nothing more than 5 separate opinions. I think there was a consensus. I think everybody's acknowledged that there's I'm not going to say an absolute, agreement, but there's a consensus of things to be included, and I think it needs to be written up, so there's a document to stand on.
I kind of feel like we confronted this issue while we were doing the evaluation. I think it was your intent to sort of amalgamate the comments. The problem is they were divergent, and, there was a document that I think you and Stephen had put together which I don't think was very reflective of the overall tenor of the five of us. So, I mean, I think, to me, that's the challenge of it.
I don't think the intent of that was to be a amalgamation of the intent of that
Okay.
was what was the next action steps. Where are we going with the next action steps, which is what Richard has put together here.
And Alex, from my perspective, what I'm thinking about can be as simple as the difference between a serial analysis and a parallel analysis, and that is, we've got everything that Mr. Grant wrote, everything that Mr. Santinello wrote, everything Mr. Foster, as opposed to saying, element one, here's what Mr. Grant, Mr. Santinello, Mr. Foster, Mr. Gold, Ms. Angelise thought. Element two, here's, and, I mean, you can include divergent opinions in the performance appraisal, but it has to come out in the right form, I guess, is what I'm looking for.
I mean, I think ultimately, see, I guess the thing is that document, if it reflects the sort of average, I know you didn't like that word last time, but if you were if it reflected the average opinion, then there are some people that wouldn't agree with that. Like, perhaps you and Marie wouldn't want to adopt that, And so, one of the things that I suggested for simplicity's sake is that you just take the part that's numerical and average those numbers, and then, okay, that's your performance evaluation on those 10 items. I mean,
If it was up to me, I'd say, just list the 5 numbers. I mean, it's not like we gotta list 500 numbers and take an average, there's only 5. List the 5 numbers, and but I'm saying, put it in a document that says, Mr. Crane's performance on this was, 2, 2, 5, 4, and 1, or whatever it was. I'm not suggesting that's how to do it, but that works as well as any other way, but it's a single document that lists it all, as opposed to saying, here's the 5 documents, that's all.
Why don't Marie and I just work on it and see what we can draft
Yeah.
up and get it out? I understand all the viewpoints that have been expressed.
Yeah.
And I'm also going to get a copy, see if I can find a copy of Robin's old review
I got it.
and can see how they finalize that one. So,
Motion to adjourn.
second?
second.
Wow.
You were second.
I guess I better ask. Discussion? All in favor?
Aye.
We're adjourned. Thank you very much, folks, and we'll see you on July 2nd.
7.
July 7th, in the same room, same time. Have a nice weekend. Not yet, our mic's off?